Good afternoon, everyone, and thank you for being a part of today's Knowledge Labs webinar hosted by the DeGroote School of Business in partnership with McMaster Alumni Association. My name is Khalid Hassanein, and I'm the Associate Dean Graduate Studies and Research at the DeGroote School of Business. I'm a Professor of Information Systems and the Director of the McMaster Digital Transformation Research Center. I'm pleased to see that there are more than 580 people registered for this discussion that includes alumni and community members from all over the world, including Kuwait, Australia, Hong Kong, the United States, and all across Canada, in addition to other countries such as India and Saudi Arabia. Today's webinar is hosted in partnership with the McMaster Alumni Association, and we thank them for the continued support of DeGroote's programming and the Knowledge Labs series. Our DeGroote faculty, alumni, and ambassadors have a depth of research and industry knowledge that they are making available through the Knowledge Labs series to support our business community's livelihood. Much of their work has focused on disruption in business, which is extremely relevant during this pandemic. The series is available through a variety of channels, web articles, webinars, and an in-the-know video playlist. I'm also pleased to share an ongoing partnership that DeGroote has started with our business communities. Hamilton Chamber of Commerce and the Burlington Chamber of Commerce. This partnership is intended to support local businesses during these challenging times and features a web portal for community members to access and submit questions to DeGroote faculty members. Using this portal, we are doing our best to share expertise and advisement that will support businesses as they navigate through these difficult times. The web link is being shared on the screen right now, and more information about this program will be shared in the email we will send out following today's webinar. I would now like to introduce today's speakers who have generously offered their time for today's presentation and to answer all of your questions. First, I'd like to introduce Tanya Walker, a DeGroote alumna and a lawyer with the firm she started, Walker Law. Tanya is a trial lawyer that graduated from DeGroote in 2002 with an honors commerce degree, minoring in economics. She then attended Osgoode Hall Law School and received her law license in 2005. She was called to the bar in 2006. Tanya practiced at two Bay Street firms before opening Walker Law, which specializes in the area of commercial litigation. From 2014 to 2016, Tanya was a member of the McMaster Alumni Board. Tanya has been the recipient of multiple awards, including the McMaster ARC Award in 2017. She appears regularly on national television stations such as CTV, CBC, and CTV as a legal analyst. Our next speaker is Jordan Rutliff, who is an associate lawyer at Walker Law. Jordan received his Juris Doctor JD from Osgoode Hall Law School in 2018 and was called to the bar in 2019. Prior to law school, Jordan obtained a Bachelor of Fine Art and worked for several years as a technical director and account manager in the live entertainment industry. Jordan focuses primarily on property law. Thank you to both for being here today, and we are all looking forward to hearing your insights on today's interesting topic. Before we get started, there are just a few things we want to go over. First, there will be a Q&A period at the end of the discussion for everyone who is watching to ask their questions. Please use the Q&A function included in this webinar today to post your questions, and we will get to as many as we can at the end of today's presentation. Please note, this event may be recorded for marketing and promotional purposes and or shared within DeGroote, McMaster, or with our speakers, participants, and other partners. By participating, you consent to this webinar being recorded and any audio or video that may be captured. Please contact the marketing and community engagement team if you have any questions. Finally, we are hoping to get your feedback about your experience today. You will be getting an email from us after today's webinar, so if you are able, please take a couple of minutes after this event to fill out the survey in the email and help us continue to improve on these webinars. With that, I will turn it over to Tanya and Jordan. Tanya?
Thank you to the Associate Dean for the kind introduction. So I am going to start off just with the groundwork and the housekeeping and begin with the agenda. So our agenda today will consist of 5 minutes of housekeeping. We will run you through on some of the functionality of how Zoom works and how you can participate in a more interactive way with today's presentation. Then we will move into part 1, where Tanya will discuss negotiation strategies and primarily the impact that COVID has had on negotiation strategies. We will then move into part 2, again, where Tanya will speak about tips on negotiation strategies. So some ways you want to maybe reframe the way you approach negotiations in light of the pandemic. And finally, the substantive portion will end with part 3, where I will discuss various contractual terms that you may want to consider in light of the pandemic. And finally, we'll wrap up with a Q&A and closing remarks. And a note that today's presentation is for general informational purposes only, and it is not intended to be legal advice. And addressing the participant questions, I do want to point out that we've had a great deal of participation leading up to this. We're very grateful for that. There were a number of questions that had similar themes or shared similar points of interest. We've tried to consolidate the questions where they had similar themes and points of interest, and we're going to attempt to answer as many as possible throughout the presentation. We also, in order to keep the names of the participants confidential, those who submitted their questions in advance, we will only be referring to them by their initials. Next slide, please, Tanya. So before we dive into the housekeeping, I just want to take a moment to invite you to Walker Law's webinars in the future. The registration links can be found on the website link provided on this slide. And our next webinar is on August 20th, and it will be on employment law issues. So we invite you to join us for that webinar. In terms of functionality, we want to start by explaining the side-by-side view. So in feedback we have received on previous webinars that we posted, a lot of participants have expressed that they would like the presenter to be on an equal proportion to the slide content. You can do that by going to the top of your page, selecting view options, and then hitting side-by-side, and that will give you a more even view of the presenter and the slide content. In terms of responding to polls, we are going to have a number of polls today to make it more interactive. We like to be able to see what your thoughts are and respond to them accordingly. And so you will see periodically a poll pop up similar to the one on your screen here. You simply select your answer option and then hit submit. And then Tanya will post the polling results that we will discuss and address throughout our presentation. And to those of you who are using a cell phone to view this webinar, please note that your view of the polls may be skewed. And for that reason, if you do have access to a laptop or desktop, we would encourage you to take a moment, transition over to that device instead if you want to be able to interact with the polls a little bit better. In terms of answering questions, the Associate Dean has mentioned this, but just as a reminder, we want to hear your thoughts. We want to respond to your thoughts as this presentation moves on. And so if you do have any questions or comments, we invite you to use the Q&A function at the bottom. You can see we've highlighted the icon for you on this slide. You just select it and then you can type in your question. We will either answer it live or answer it in writing. And for those of you that have written questions that we didn't get to throughout the presentation, we will do our best to read out those questions at the end of the webinar during the Q&A portion and answer them live at that point. In terms of the objectives, we really have two primary objectives today. The first is to help you understand the impact that COVID-19 may have on how you negotiate. And the second is to help you understand some contractual terms that you may want to consider in light of the pandemic. And with all that housekeeping out of the way, we will now turn to our first poll of today's webinar. So we want to hear from you. What topics are of most interest to you? And here we have 4 options: how the pandemic has affected the way I should approach negotiations, tips on how to negotiate, pandemic paragraphs to put in your contract, or other. And if it's other, please use the Q&A function so that we can get a sense of what is on your mind. Please vote.
We'll give it about 5 more seconds.
All right, so the overwhelming majority is looking to get some tips that they can add to their toolbox on how to approach negotiations in the future, and that will be primarily addressed in part 2. But if you have any specific questions, please feel free to answer them. And with that, we will now go to part 1, and I will turn it over to Tanya.
Thank you, Jordan, and thank you to the community and the McMaster community for having me here. I'm excited to be here. So in this section, we will describe how negotiations have changed due to the pandemic. We will also discuss errors that are commonly made during negotiations and provide tips on how to improve your negotiations. The pandemic has caused uncertainty, and it has changed the way that we are used to doing business. We are used to negotiating while physically sitting across each other in a room. Now, physical distancing is the norm. Also, even if you are in the same room, it might be a little bit difficult to negotiate or see that person's expression because you might be wearing a mask. This uncertainty and change in how we negotiate is probably what has caused almost 600 of you to register today. Typically, we learn about a negotiation strategy called BATNA, which it stands for the best alternative to a negotiated agreement. This looks at trying to get the best deal for yourself and yourself only. And if you're not able to, you seek other alternatives. The problem that we now have is that many of us do not have any other alternatives. So this section will explain the traditional negotiation style and how that has changed now that we are in a pandemic. So questions that I will specifically address in this section are, how have negotiations changed during these uncertain times? We received around 150 questions, and I would say this is about 1/3 of the questions that we received. And also, do you ever split the difference when you negotiate? And that's a question from GW and RD, so thank you for your questions. So I want to start off with giving you an example, and then I am going to run a poll to see what you think about this example. So pretend you are a purchaser of a car and you want to buy a 2010 Honda Civic. And so you decide to yourself, I'm going to buy a Honda Civic, and I know that there is instability in the market. There aren't too many people looking for cars right now, but you also know I don't really want to spend too much time shopping right now. I don't really want to be out of my home. So you look at what this chart shows is your best alternative to your negotiated agreement and your worst. So your worst alternative is that you don't buy the car, or you spend an expensive amount for the car, say $100,000 for a 2010 Honda Civic. And that's just that doesn't work for you. You walk into the dealership, and the dealer who's concerned about selling cars wants to make sure that the car is actually sold. So the worst alternative for the dealer's negotiated agreement is not selling the car, or selling at such a loss it doesn't even make sense to sell the car. And you start to negotiate because you're hoping to get into this circle here, this circle here, which is your BATNA. And your BATNA is the best alternative to your negotiated agreement. And you're trying to get to a point where both of you agree on a number. So you're trying to get into here. So does that make sense? So you decide to buy the car, and you're $200 off in terms of your negotiations. And you say to the dealer, you know what, we're $200 off. I need to move on with my life. Let's just split that difference in half, and I'll pay $100 on top of my bottom line. So you end up paying $100 more than you wanted to, but it's still within your range. So my question to you is there anything wrong with this negotiation? So one, it's fine. 2, you did not consider the long-term relationship of the parties. 3, you did not take into consideration other ways to increase revenue or decrease cost. B and C, unsure or none of the above. Could you please vote? And I'll give you about 10 seconds to vote. And I will close it in about 5 seconds. Closing the poll now. and I'll share the results with you. So the number of you, 41% of you said B and C. It did not consider the long-term relationships of the parties, and it did not take into consideration other ways to increase revenue or decrease costs. What came in second place is C, did not take into consideration other ways to increase revenue or decrease costs. Some of you are unsure, and some of you say none of the above. If you believe it's none of the above, please let us know why. So the correct answer is D. The majority of you got that. So I have taken this approach personally with my clients. We are in a settlement negotiations, and on the eve of trial, my clients say, Tanya, I'm tired. Let's just split the difference in half and let me move on with my life. And so I say, okay, and we settle, we move on. But the majority of you are correct. We didn't take into consideration the long-term relationship of the parties or other ways to increase revenue or decrease costs. And if that had been explored as a purchaser of a car, you might have explained to the dealer that you're actually interested in purchasing a fleet of cars for your business. And the dealer might have been able to explain to you that he has or she has an overstock of cars that he or she wants to get rid of in the upcoming months. And you might have been able to negotiate lower than even your BATNA, because you would have entered into side contracts to purchase cars later on. So not looking beyond your immediate needs or even the contract is a standard way to negotiate a contract. You're looking for the best deal for you and only looking out for your objective. So before you usually negotiate, you complete your research. Logic is really a huge component when you negotiate with BATNA, the traditional method. You know the facts, you analyze the facts, there's education, there's research. But the problem nowadays is that we are in a pandemic, and a pandemic leads to uncertainty and might lead to us being a little bit more emotional with our decisions. We are concerned about desperation, that there might not be any other alternatives. We don't know what there might be in the future. And so if you have a little bit of desperation where you want to sign a contract, this will lead you to forego focusing on the logic and focus a little bit more on your emotion. Just like in the car example, where you knew you weren't supposed to really be outside shopping, you'd rather be home, and that's why you agreed to pay $100 more than your lowest price because of that emotion. So what happens with increased emotion? This leads to the main mistake that I've seen as a trial lawyer. I've been practicing for 14 years, and starting with the pandemic, I've seen these type of decisions taking place. The first is providing discounts. There's nothing wrong with providing discounts, but you should keep in mind that the number that you provide as a discount may actually be your permanent number after the pandemic is over. People talk, and someone may say to someone else, you know, this is the price that they'll offer, but you can get them down to this price. So that might be your permanent price. And instead you really should focus on value. The second is not fulfilling the terms of the contract. So by overpromising. And we had that happen in our firm, where we asked a supplier to provide a particular item within a month, and the person said yes right away. And I was quite surprised, and it ended up being shipped to us 1 month late. So there's an overpromise on results, leading to not a long-term relationship. And also, because you may be quick to sign that contract, you don't think about renegotiation opportunities or ways to help each other outside of the contract. So the biggest change that I see with COVID-19 is that there is the need to approach negotiations holistically outside the transaction. You should consider, how can I help the other side in its ecosystem outside of just, lawyer client, supplier client type of relationship, employee employer? How can I help that person? And it requires you to step back and not focus too much on your needs, but to look into helping theirs. So holistic negotiations are very important nowadays. So that leads into part two. And part two is the negotiation strategy. Here's a toolbox. And the reason why this picture was selected is because I want to provide to you 4 tips to put in your toolbox, these 4 tools, so you can take a holistic approach to a negotiation instead of a transactional approach. We received many questions, and I believe this is the majority of you that are viewing this webinar today want to hear about tips. I believe it's around 41%. So tip number 1, before you negotiate, review your approach to goals. So I'll provide an example to you. I'm about to participate in a negotiation with someone. Before I attend that negotiation, I send an agenda. The agenda will contain a line item that says, please let me know your goals and your challenges holistically outside this transaction, your business goals and challenges. I send that to that person so they start to think about it. In the meantime, I think about it myself and I jot down notes on, okay, what challenges is the other side may have right now and what are their goals? With businesses, it's usually they want to increase revenue, decrease costs, but there are other things, might increase branding, or they want a certain type of relationship to, or an introduction with somebody. So I think about those before I even attend the meeting. When I attend the meeting, I remind that person, I know I'm a lawyer, but just to remember, I asked you about your goals outside of this transaction, and start a dialogue, and I listen. I do not interrupt. I take notes and I see, do these pointers or these tips match with what I have written down? Because sometimes they match and sometimes there are other things I haven't thought of. When that is finished, I share my goals and our challenges that we have. And while that person is also explaining their goals and their challenges, I'm also thinking of ways of how can I assist this person? Is there an introduction I could make? Should we align our services to decrease costs? There's something that I'm always thinking about as they speak, and I jot it down. So 2 questions that were asked of us that I thought were very applicable to this section is from DD. Any particulars that should be considered in negotiating between a Canadian provider and US company in these times? And if I'm the Canadian provider, because I'm in Toronto, I would consider what goals does this US company have? Is there anything else I can provide to this US company? Or is there anything that this US company may need that I can help facilitate the introduction or even align with that US company? The second question is from KD, how to prioritize what is important in a negotiation and the immediate long-term needs of the team and of the organization. This is a brainstorming session. And so I don't always like to say that something is long-term, because when you negotiate or you're comfortable sharing your needs of the team and the organization with someone else, they may be able to assist you right away. And that might end up being a short-term goal. The second point is scope. So now that you've brainstormed all your goals and you've shared them with each other, and if that person is a colleague that you have a good relationship with, personal goals are also important. I had a negotiation with someone that I've known for 10 years, and she said to me, I bought a home in a different area outside of Toronto and I need gym equipment. And I was able to introduce her to an owner of a gym who was able to sell her the equipment. Completely outside our transaction, but it's because we shared our goals with each other. That helps to create the long-term relationship. The second is scope. So how do we help each other outside the transaction? And this might end up, you might end up broadening the scope, but you might also narrow the scope. And I will provide to you an example of how you can narrow the scope. A few months ago, someone approached our firm and said, I want to fire my lawyer and hire your firm. I heard that when you represent the plaintiff, the person who is suing, you are very aggressive. You help them get their money very quickly or to trial. And I explained, yes, I do take that stance, but what is the problem? What is your goal other than getting a settlement very quickly? He said, I need someone who's more aggressive on the matter. I said, well, is there a problem with the competence of the lawyer? Do you think there's an issue with that? He said, no. So I looked at the matter and I realized it's an issue. The lawsuit deals with securities law and employment law. And I'm not a securities lawyer, I'm a commercial trial lawyer. And so I realized that if I were to take over this entire matter, it would involve hours of us learning securities law, which I really don't want to learn in my 14th year of practice, or we can just focus on the employment. So I said to the client, here's my proposal. why don't we make that lawyer our co-lawyer? So we work together and we'll take the lead on scheduling. I'm fine with being aggressive for you, but we will divide the issues into two, securities and employment, and I'll just deal with the employment issue. And he said, that's perfect. So it was narrowing the scope, but we were able to assist him, and we were able to also assist ourselves because we saved time learning something that we will not even charge him for. So that's a way to, you could also narrow your scope. So questions from many people, including RP, MJ, MB, EB, IH, and SO, is how do I negotiate effectively despite challenges in the pandemic? I don't necessarily want to think of our pandemic as being a challenge. I think of it as being an opportunity. If it were not for the pandemic, I would not be presenting a webinar to you today, and I get to virtually meet all of you and share my knowledge. So it really is looking at opportunities at a time like this. So then you have the third point, which is leverage. And leverage is what can you use what you have to negotiate. And what ties into this a little bit are questions that I saw about race and about gender. Some of you wondered, okay, well, how do I even have leverage when I'm racialized or I'm a woman? And so I'll kind of tie the answer together. What I like to do is just focus on the value that I can bring. This whole exercise is based on showing to the other side the value you have, the value of having a relationship with you, and that creates leverage. An interesting study by Kellogg Business School and Harvard Business School on a test, just a test group of people, not a huge group of people, visible minorities, showed that 50% of the visible minorities did not actually negotiate as hard as they should because they did not feel that they were entitled to receive what they were asking for. Another 50% of the people on the other side of the table did not negotiate with the visible minorities in the same manner as they did with people who are not visible minorities because they felt that they were not entitled to ask for what they're asking for. So if you are a visible minority or you are a woman, keep in mind, this is not a scientific study, but you could be part of that equation in terms of not getting what you believe you're entitled for. I have dealt with many negotiations throughout the years, whether it be with opposing counsel, with my clients, with a judge, with suppliers. And I don't know if someone actually negotiates with me in a tough way because they're just a tough negotiator, or because I'm a woman, or because I'm Black. I have no idea. But when it comes to dealing with a client, I focus on the value. I don't think about that at all. It's beyond my control. And I focus on the value that I bring to the table. I focus on explaining to a client that the rate that we charge is the market rate for lawyers of my year of call. And what brings value to you is that I have experience with many trials. I've argued at the Court of Appeal, which is the highest level court in Ontario. I have also appeared on 4 television stations. I've also practiced at 2 Bay Street firms before I opened this firm 10 years ago. And I have wonderful training by DeGroote School of Business in business, so I can understand the business aspect of your matter. So that's the value that I focus on, and that's what I use to negotiate. A number of you have asked employment-related questions when you registered, and there's some initials there. And how do you negotiate a pay raise or employment contract during a pandemic? What I would suggest that you do is think about what your employer is interested in right now. And usually it's increasing revenue, decreasing costs. So if you are employed with a financial institution, you may have finished a project early and saved money, you saved in the budget. So that's something that you may want to bring to your employer. So if you're negotiating an offer, consider value that you'll bring, consider what your employer may need from you outside of the contract. And if you're negotiating a pay raise, then you would consider what have you done to help your employer become more successful. And my last point here is timing. You should act very quickly. So if you are the person with the unequal bargaining power, so you may be the employee, or you may be the person who will provide the product, and you need that company to say yes to you, and they're taking a lot of time because they feel that you don't have many options, you should ask for deadlines. Say, now that we've had our discussion, when can we move on to the next step? But in the meantime, if you feel like your time is being taken for granted, use that time wisely to do what you can to increase your leverage. And I'll give you an example of this. So I went through on-campus recruitment at McMaster University around September 11th, 2001. I graduated in 2002. And during that time, I had received many interviews. I was very grateful. September 11th happened, and then a number of companies, pretty much all of them except for one, said to me, Tanya, we can't extend a job offer to you because we have to put that on hold due to the uncertainty in the environment. I thought to myself, I don't really think this is such a big deal, because to put our job on hold, not September 11th, because Fortune 500 companies make quite a bit in comparison to what you pay a person who graduates from university. But I said, okay, that's fine. And I accepted the one offer that was presented to me. A few months later, a number of those companies called me and said, okay, Tanya, we've been given the green light. We'd like to extend an offer to you. And I said, at this time, I've already accepted my role, or accepted an entry into Osgoode Hall Law School. And as a result, I don't want to leave a job for another one than to start law school. That's not a good thing to do. But if I was not planning to attend law school and I was considering leaving that job that I was with, then I would have had more leverage to negotiate salary, because I had a few more months of work experience under my belt. So it's very important to act quickly. And if you can't act quickly, or you're concerned because there's uncertainty, to be open, create that dialogue, and maybe even enter into a temporary contract for a few months, and you can revisit it down the line. So a question from PT is, when is it best to bring in legal representation in the negotiation process of a business contract? And I would say that once, with the timing, if you are negotiating back and forth and you have your main points written down or main points agreed on, then that's a time when you should say to a lawyer, and I'm not a corporate lawyer, so it wouldn't be me, but you would say to a lawyer, we have our main points agreed on. Here they are. Could you put that into an agreement and let me know if there's anything else that's missing that we can put in there to protect ourselves? So to conclude this section, literature about negotiations, we were asked questions from TBRC and SR about courses and books for negotiations that we would recommend. And I have to really emphasize the DeGroote School of Business. Most of you are McMaster alumni, so I'm sure you will agree with me. But I would not have been able to run this practice for 10 years and have the business acumen, those tools in my toolbox, if it weren't for my education that I obtained at McMaster University. I'm grateful that accepted me into the school. And there's one course that's coming up on October 29th on negotiation intelligence, theories and practice leading to impactful outcomes, that I recommend that you enroll in. The second is I really like reading about business, and one of my favorite books on negotiation is Getting to Yes. And it's pre-pandemic, but it provides the tools for you to help you negotiate successfully. So that summarizes my discussion on negotiations. Jordan will now speak to contractual terms.
Thank you very much, Tanya. So an introduction to this section, we are going to be answering participant questions regarding contracts and negotiations. We will then provide some tips on terms that you can use to address the future effects of the pandemic. And you may want to consider including these in your contract. For instance, just as an example, as a tenant, you may want a term that will prevent you from having to pay rent if for some reason your business is closed down. That's just one example, but we'll get into it a little bit in further detail, the mechanics, when we progress into the slides here. And as a starting point, I would like to address the questions of LT and NS. You can see them at the bottom. Both of these questions relate to verbal contracts. And just as a general note, we would never advise anybody to rely upon a verbal contract. Part of the reason is that they are notoriously difficult to prove in court. You have to introduce all kinds of circumstantial evidence, emails, text messages to create a picture of what this verbal contract was and establish in the court that it actually existed. And so for that reason, it's never advisable to rely on a verbal contract. Now, another question in terms of how you manage negotiations, verbal negotiations, not pen to paper, and as things move along and people are changing their positions, you may want to consider the use of a memorandum of understanding. It's not a binding contract, but it is a way that you can essentially memorialize some of the initial terms that were agreed upon for reference as you progress through the negotiations. That way, all of the critical junctures of your negotiations are on paper for reference. You can call them back up and there's no confusion about where you left off. Next slide, please, Tanya. So the bulk of this section focuses on the concept of a force majeure. Now, this is a very popular concept these days, very popular contractual term. And essentially what a force majeure is, the literal definition or translation is a superior force, but it is a term that is in a contract that addresses scenarios outside your control, outside of the party's control, and it can be a pandemic depending on what the term says. So if you have a force majeure, the benefit of that is that if it references a pandemic, for instance, you may be temporarily or permanently relieved of some or all of your obligations and responsibilities under the contract, again, depending on what it says. And so going to ST's question, have you encountered many cases involving a force majeure since the pandemic began? Surprisingly, well, I suppose not surprisingly, the answer is no. And the reason is that nobody contemplated that it would occur. And so the language just wasn't there to address the pandemic. Next slide, please, Tanya. So we have a question from LC. Is the pandemic a force majeure scenario? And that prompted us to include this poll. So here is our scenario. Your supplier is saying that your contract with them has a force majeure paragraph, so they do not need to supply you with the items until the pandemic is over. What do you do? Find an alternate supplier, nothing, insist that the supplier deliver the items, unsure, or none of the above. Please vote.
So we'll give it about 10 more seconds.
So the overwhelming majority said find an alternate supplier. We have a small portion that says nothing, and then another one, the other largest portion is insist that the supplier deliver the items. And going to the next slide, the answer is actually none of the above. And the reason is when somebody cites a paragraph, your first step, or a force majeure clause, the first step is to determine whether it actually applies. So you need to examine the term, see if the scenario is contemplated, and then you would act accordingly. And that brings me to my next slide. So how do you utilize, or I suppose respond to a force majeure? So your first step is, does it apply, right? So at the outset, you want to look at the term, see what the scenarios are that are contemplated in the term, and what events are defined, and then from there, you will have a sense of whether or not the force majeure applies. So usually you'll see references to war, labor strikes. It could be a pandemic, but you'll have to look at the term, see if it applies. The next step, step 2, if it applies, what are the consequences? And so here, the important note is a lot of people have this misconception that a force majeure basically means contract is at an end if it applies. That's not always the case. Oftentimes a force majeure is structured so that certain responsibilities are taken off the plate, but the contract remains in place. And so you have to look at it and see, okay, if it's triggered, what does that mean? Does it mean that I'm only relieved from delivering half of the items that I was supposed to deliver by a certain date? Am I entirely relieved from that responsibility? the term of the contract will govern what happens. It may be the case that it says that the contract is at an end, but you'll have to take a look. The last step, and I think this is the most important one given the topic of this presentation, is how do you address the activation of this term? And so this goes to the questions from AL and BK, which is how do you deal with a counterparty citing a force majeure? And the key here is to negotiate, right? Just because a force majeure is in the contract and it applies doesn't mean it necessarily needs to be followed to the letter. Oftentimes, parties do not want to compromise the relationship and they don't want to terminate the contract. They simply just want to make it workable in light of surrounding circumstances. So get on the phone, talk to them. Are there ways that we can inject some sort of momentum from an outside deal? Is there some sort of way that we can incentivize the parties to move things along, right? You should really get on the phone and negotiate. It doesn't mean that you have to just stop and take the provision, the term at face value. So to give you an example, we'll go to the next slide. Here's a case, Fishery Products International Limited versus Midland Transport Limited. And basically in this case, one of the parties tried to cite a force majeure saying that it contemplated a strike. Now, what the force majeure did contemplate was a protest, but a strike and a protest are two very different things. A strike is usually a union labor mechanism where employees essentially raise grievances in a formal way regarding their employment contracts, the state of their employment. A protest anybody can have, right? Any group can organize on the streets and have a protest, two very different definitions. And the court said, I'm not going to analogize or construe a strike to be the same thing as a protest. By definition, they're two very different things. And for that reason, the court chose not to apply the force majeure. So the golden rule here is, if it's not clearly defined, it won't be implied by the court. The court is not going to inject meaning into the language for you. It's either defined or it's not. And that brings me to the next slide. So here's an example. We've had a couple questions regarding leases. So you can see from KR, suggestions to consider when re-signing a lease, and is a lease necessary? And do you believe that agreement should have a force majeure? So here's one example of where a force majeure would be appropriate, is in a lease. So if you are the tenant, it would benefit you in these times to have a force majeure that would relieve you from your rent obligations. So we'll just walk through quickly through this term. Should a force majeure event occur during the leasehold improvement period, that's a period where the tenant is renovating the property before opening, and laws or regulations prohibit the business from opening thereafter, the landlord shall not repossess the unit or distrain the tenant's assets and shall waive the rent, so on and so forth. Basically what this term is getting at is, if for some reason there's an event that's defined in the paragraph and that event leads to laws or regulations that prohibit me from opening the business, you're not going to call on me to pay rent, and you're not going to take any action with respect to those arrears in rent for at least 3 months, right? So this is a way that a force majeure can be used for you, used to benefit you in times of uncertainty. Of course, on the flip side, the landlord may not want a force majeure because they may want to ensure that rent continues to flow to them. Next slide, please, Tanya. So in closing, I want to again, or we both want to thank you again for joining today. We hope you enjoyed the webinar. For those of you who joined partway through, we do want to remind you that Walker Law hosts some webinars from time to time. Our next one is on August 20th on employment law issues. You can join through the link that's provided on this slide, and we hope to see you in the future. And with that, we will turn over to the question and answer period.
Okay, so we received a number of questions. What I'm thinking is I can answer them out, Jordan, and you can maybe type or you can chime in. What do you think?
Okay.
Okay, and I'll stop the share for now. And so one question is, what is the best way that we can create urgency during a time of uncertainty? My thoughts are that it would take, you would take time and explain what your deadlines are and why your deadlines are important to you. And if it is just even making you feel a little bit nervous, waiting around or the uncertainty, to explain that to the other side if you're comfortable doing so. So that's the only way you really can create urgency, unless you have another contract that you might have to fill, or another job offer out there. Sometimes what we do, we create that open dialogue with our clients. If someone is thinking about hiring us, and I know in the next month I have about 9 court dates, I would say to that person, you know, you might want to make a decision fairly quickly because I have 9 court dates and I like to be able to spend time on your matter properly. I don't want to rush and work on your matter at the very last minute. Another question is by MB. Can the email communication be used for a legal binding agreement?
Sorry, Tanya, I just answered that one in writing.
That's okay. I can say it out loud because
Okay.
people can't see it anyway.
Okay.
So you can't, I don't know if it's a binding, I've used emails and text messages, Facebook, WhatsApp in court as evidence to show a judge what your contract is. But I really would prefer, I spent a lot of time when I have to prove a contract that way. The best thing for you to do is probably create a written contract and agree on those terms. But if you don't have one and you have these emails and text messages to show what your contract is, and then we can show that your actions are in accordance with what is written in that email or text message, then that would create a legally binding contract. Because you only need 3 things for a legally binding contract: an offer of something, acceptance of something, and exchange of money. It's called consideration.
The only thing I would like to add to that, and
Yep.
I put that in the written response, so just to join the verbal and the written response, you also should be aware that some contracts will have language that basically says no document, information, email, anything outside of what this contract says is binding. It's often referred to as an entire agreement clause. And so you're going to want to be conscious of that, right? Just because it was in writing prior to the contract doesn't mean necessarily that that will carry over and be binding once the contract is signed.
That's true. But the thing about judges is that the courts are a court of equity and fairness. So then if you have even if your contract says nothing outside the contract is binding, but you have something outside the contract and you've been acting as if it's part of the contract, it might be seen as part of the contract. So it's because they want to do what's fair. What else is there? So by BK, what is the thinking of if a pandemic is not mentioned in the force majeure clause? Does it cover the pandemic situation? So Jordan, you want to take that one?
So
I think he said you answered it, but I think it was if it doesn't say pandemic, if it doesn't speak to that specific language, it will not be covered.
Right.
Another one by IT, if a client has put a recently renegotiated contract on hold due to COVID and then has extended the timelines for restarting it multiple times, how should I as a small business owner deal with this? So the issue is there's a contract that you have renegotiated and they said they're putting it on hold till say the end August, and then September, and then October, and then November. And then how do you deal with this as a small business owner? I would say to them, I would think of, first of all, what is their goal? And their goal is probably to save money and this is a way to deal with uncertainty and trying to save money. And I would explain, I'm a small business owner and I would appreciate maybe not putting the contract on hold, but maybe part of it on hold if they're ordering a product or supply from you, and maybe a small partial order, so then you can generate income. But if they keep on kind of putting you off, then maybe that's a time to strengthen relationships with other customers or ask for other introductions to make best use of your time to generate income for yourself.
So we have an anonymous attendee, another force majeure question. If there are instances such as hydro, flood, but a pandemic is not specifically listed, what can we do? And what if the contract only talks about force majeure for one party and is silent on the other? So those are
let's read it a little bit slowly because people can't see it.
Okay.
I think maybe if you can, I think we have the setting where it's answered. Oh yeah, I think they can. I set it to all questions. So okay. So you could go ahead and answer it. I just want to make sure people could see it.
So the first part, what if the force majeure only talks about one party being able to use it? It could be the case that only one party benefits from the force majeure. So that's not, illegal in any way. Parties can negotiate freely. So it may be the case that only one party is able to activate the force majeure. So you'll have to refer to the language. The other thing is, if the scenario such as a pandemic is not explicitly contemplated, then it's not going to be implied from the court. So you may want to take the opportunity now, if there's a renegotiation period coming up, to change that language for the future.
That's a good one. So I see another one. How do you find out the parties WATNA and BATNA, so their worst alternative and best alternative? What I usually do, sometimes I ask, depending on the conversation, but really realistically, if I'm dealing with settlement for a client, they're not going to tell me what their worst alternative is. But I could also guess. With decisions in court, they're made public. There's some people who want things to be kept private and not accessible by others. So that is the worst alternative. Even if they win at court, they lose because you have this decision that's circulated. So you can probably brainstorm and have an idea of their worst alternative, and their best alternative is pretty much is getting what they want. Worst is not getting it at all. Or you can have a discussion, and while the person's brainstorming, you could probably have an idea of what the best and worst is. What else is there? I'm having.
There's an interesting jurisdictional question.
Which one?
I am a Canadian buying a business in New York. Where should my lawyer be? I would say that depending on the circumstances, you may want both somebody from the New York bar and somebody from the Canadian bar.
Oh, but one thing to be careful of. This is what this has happened to us before, Jordan. That we sign agreement and it says, you know, it's governed. Any issues are governed by the laws of like Delaware, and I don't know. I'm not familiar with those laws. So if you're a Canadian buying a business in New York, you really should try and have a lawyer retained for you in New York. But also make sure that if you have any paragraphs in your agreement that deal with where do we deal with disputes, you have it dealt with in a place where you're comfortable with those laws.
Right.
What else? So how do you address force majeure event under the terms and conditions? Typical. Okay, so how do you address a prolonged force majeure event under these terms and conditions? Oh, because this is a long time for a pandemic, I guess. And and we don't know when it's going to end. It can end next year. I heard this morning on the news that there's some workplaces that will keep their people working from home till next year. What are the typical relief under prolonged force majeure event that you can negotiate? Do you want me to take it or do you want to take it?
I can go for it. So
go for it.
I think the key thing is going back to step 3 of the chart Tanya and I put in, which is renegotiate, right? Just because the force majeure event has been triggered doesn't mean that you have to stop working out solutions with the other side, right? So going to, I think it was point 4 of Tanya's portion on tips for negotiation, use the time wisely, right? Just because the clause is triggered, don't, sit back and wait for it to pass over. Think about, what other solutions could be developed. Are there sort of outside means that I can use to leverage negotiations, renegotiate the contract? So try not to be static, even though that this event is prolonged.
There's a question from MH. If we want to litigate, so sue a private U.S. company that is based in USA and does not do business in Canada, can we use Canadian lawyers who need to hire abroad? It depends on what your contract says, but just keep in mind the reality of things. Courts have slowed down a little bit. We're now really into Zoom and doing our court dates on Zoom, but there's a backlog. And if a judge does not have to deal with something, the judge probably won't. So if the test, like our rule book is fairly thick. This is our court rule book. And one of the rules say that you really should sue a person in the area where the wrong happened. So you look at where the contract took place, you look at where the witnesses live, and that's a law that kind of governs. But if you have a contract that speaks to, like I mentioned, New York or Delaware, it depends though, because there's a Supreme Court of Canada Uber case that just came out that dealt with this issue. But typically speaking, you would sue in that area. You wouldn't sue here, because if you sue here, then they might say it's a wrong jurisdiction and might make a request to a judge to have your lawsuit thrown out. And it probably will be because they can't, the laws don't apply to your matter. Okay, so we have about 5 minutes left, Jordan. I think we only have time to answer one more.
Okay.
thank you so much for your questions. This is exciting. Do you want to select the?
Sure. How about what are some tips from AA? What are some tips for maintaining composure while negotiating? For example, some woman may be accused of being too nice, etc.
I stick to some tips. I think it's just sticking to the facts and being calm and realize this is a business. Most of the time, it's a business transaction. It's nothing personal against you. And sometimes when you realize things are not personal, you don't take it personally. I do find that there are sometimes remarks made about people and their negotiations based on gender. I think at my level, 14 years, litigations that I see, men, it's about 90 to 95% men. And I hear comments, but I don't really worry about it. I'm respectful, I'm polite, and I hope that goes a long way. And I'm an advocate for my clients. I wouldn't, but I'm also, when I do believe in a point, I'll make it clear I believe in a point, but I'm not disrespectful. So I hope that helps. I think it just depends on the type of negotiation, depends on the people that you're dealing with. Some people, if I'm familiar with opposing counsel, I act very different than if I don't know opposing counsel or opposing counsel is really not nice at all. So it just depends. Okay, so we're at 1:57. So we have to ask the Associate Dean to return back to us, and I'll share my screen. And so,
okay, so
thank you so much for having us, and I'll leave it to you to conclude.
Okay, thank you again to Tanya and Jordan for your time today and sharing your expertise to answer all of our questions today. I think we all learned a lot about this topic. We hope you all enjoyed today's webinar as well, and thank you everyone, and take care.